Thank you very much, everyone, for attending this COVID update. Where are we now on procedure and claims? Well, we know that there's been very significant effect of COVID on us now over the last year. We've had court closures, we've had vacated hearings, we've had civil listing priorities imposed on us, and we've had virtual hearings. I just wanted in the first instance, if I may, to deal with a number of procedural and background matters, many of which you will be familiar with. PD 51Y, that's the video and audio hearings that was in force, that is in force for as long as the Coronavirus Act 2020 Section 75 is in place. We did have the extension of time limits that was in force up until the 30th of October, increasing the numbers of days that the parties could agree to extensions. We're now back to 28 days, as you will probably know. We have had a large number of cases that deal with issues relating to COVID. I just listed a few of them. Municipio di Marina against BHP Group and others. That dealt with extensions of time, vacating hearings, and that was an early on case way back from April 2020 that makes useful reading. More recently, we've had Akikova against Metsa Drunanopane, which again was a case concerning adjournments. Here, the adjournment was refused, and this now seems to be very much the way in which matters seem to be developing. That was on the 24th of July 2020, and then very recently, Ashford against Wilson, which was again a refusal of an adjournment after a defendant alleged he wanted or needed to self-isolate but couldn't provide any evidence. So the general approach I think that we're all experiencing now is that cases are going ahead regardless of COVID. In terms of the format of hearings, we've probably all had experiences of mixed hearings, either entirely remote or hybrid, where it's partly remote and partly not. You can see a couple of those particular cases. One, which is a children's case, dating back again from June 2020, but a more recent one of Langley against GMB. And indeed, I've had an experience of dealing with these, as indeed probably have you, of dealing with hybrid hearings. I must say, on my own account, I think hybrid hearings are very difficult. In the case that I dealt with, there was a trial that went on for 3 days and then submissions on a fourth. My opponent and all of the claimants' witnesses were by video link, and myself and our witnesses were in court with the judge. It did make it very difficult to be able to judge exactly what was going on with regard to the witnesses themselves, to how to probe them properly at times of cross-examination, to be able to understand in truth what was happening. And there were some remarkable moments when witnesses seemed to be in some difficulty, and then their internet connection became faulty. So it has to be said that hybrid hearings are not satisfactory, or entirely video hearings, in my view, that themselves, particularly when they're trials. Of course, I don't think that matters as far as interlocutory hearings are concerned, but I think it does affect trials. And I think generally speaking, the judiciary takes a similar view, and one would hope that trials will resort back to being in person in their entirety. But as we know, it very much depends on where you are. Birmingham, for example, is listing all of its trials in person if they're multi-track trials. A couple of other cases I thought were rather useful. One of which was Fottles against Bourne Leisure. That's a county court case, which addressed the issue of furlough and whether or not, in those circumstances, a witness could give evidence. And that similarly is an issue which I have had the opportunity to have argued out with the same outcome, although on the facts of my case, I was seeking to persuade the judge that in actual fact the witnesses shouldn't have to give evidence and indeed had to provide witness statements whilst they were furloughed. Judge disagreed, trial went ahead, case settled. And then a bit like the cat incident that we saw on the television last night, where one of the lawyers superimposed a cat over his face. One of the hazards of remote hearings is people being heard to say things which would then be potentially held against them when in circumstances where in other circumstances when they may not have said anything because they would all be together in court, or alternatively wouldn't have been heard. So in terms of bias, a useful case, again, a children's case called Re-C. We've got the HMCTS's weekly operational summaries. They're still coming at us, as we know. They tell us that an awful lot of our courts are now open. Of course, most of these don't affect us in the personal injury and civil field. Our experience in chambers certainly has been that since the most recent lockdown, very few, if any, cases in actual fact have been vacated and everything is going ahead. But of course, the difficulty for all of us, in actual fact, is not the question as to whether or not the case will or won't go ahead due to whether it's going to be remote or by video. It's really to do with the order or sequence of importance. And as we can see, even on the 8th of February 2021, for county court work, matters for which we might be interested in come 10th, 11th and 12th in the list of importance. And so we get barged further down the pecking order. So how has COVID affected us then in terms of our ongoing cases, and what sort of things do we need to be looking out for that are of some significance and importance to us and our respective clients? First of all, it has affected negatively our claims for damages. This obviously to the advantage of defendants and to the prejudice of claimants. And we can see a large number of issues here that will need to be addressed. First of all, travel. Of course, no one's been traveling. So travel claims that would have been in our schedules potentially for the last year or so, and for as long as the COVID emergency goes on, those losses will seek to be irrecoverable. Of course, they haven't been incurred, but nonetheless, those losses that we would have pleaded otherwise in our schedules at an earlier stage as claimants will need to be amended out. Same applies to care. It may well be that in certain instances, carers have not been able to get into the home. This may be gratuitous care, for example. Again, the schedule of loss will need to be amended. Same applies to medical and treatment costs. As we know, one of the great difficulties everyone has had during the COVID emergency has that inability to be able to access treatment. So those similarly will have to come out. Increased holiday expenses will have to come out. And then, of course, we have loss of earnings during COVID. And then there are a number of different scenarios there. Of course, with regard to all of these heads of loss, we're not out of the woods yet. Who knows how long in natural fact it's going to take before we get back to normal. So we know we have to address these issues, not simply with regard to amending our schedules of loss and potentially redrafting our counter schedules to address these particular issues and ask for further disclosure, etc. But we also have to apply those particular issues into the future and amend our schedules in those respects too. And of course, with regard to loss of earnings, it may be that there's no change. It may be there's been a furlough with reduced earnings, or there may be lost employment. And the consequence of which is that there's no loss of earnings at all during the COVID period, which, as I say, might in actual fact go on for some significant period, particularly for certain people who had occupations in hospitality or travel. And it's difficult to see when it is that those sorts of things are going to be back to normal. Perhaps not until the back end of this year, perhaps not for years in the same sense, that the types of jobs that were available prior to COVID are going to be available to us in the future. And particularly that may apply to retail. I mean, for example, with the huge and massive numbers of insolvencies and losses of high street retailers and their closing down, or all of those cases that involve loss of earnings by claimants will now have to come out of schedules, and a great deal of rethought put in as to what career path those people might be able to pursue, assuming that long term there's going to be a lesser number of people involved in retail. What about working life multipliers and contingencies other than mortality? One of the interesting points that occurred to me was the question of long COVID. Just how is this going to affect the contingencies other than mortality? Of course, we have tables A, B, C, and D at Ogden, 8th edition at Farrar 82, which tells us what the contingencies other than mortality are. But of course, those are based on a pre-COVID era. What about long COVID? How will this affect the statistical likelihood of working? And just to think about the nature and extent of this particular problem, there are 3.97 confirmed cases of COVID in the UK. What about all of the unconfirmed cases? The ONS produced a statistic that 1 in 65 people tested positive for coronavirus within the community population in England during the week ending the 30th of January 2021, which equated to 846,000 people, or 1.55% of the population. As I understand it, in the weeks preceding that, it had exceeded 1 million. It was reported in The Independent that in December, data released from the ONS showed that 1 in 10 people infected with coronavirus experienced symptoms that lasted longer than 3 months. And on the 7th of September, a study reported that 60,000 people in the UK had been suffering from long COVID for more than 3 months. And on the 20th of August, a study published by Southmead Hospital in Bristol found a total of 81 patients out of 110 discharged from hospital were still experiencing COVID-19 symptoms, including breathlessness, excessive fatigue, muscle aches after 12 weeks. So what's clear from all of this is that our approach to tables A, B, C, and D at Ogden 8 at Farrar 82 will probably need to be reprised, because a significant number of the people, either current clients or future clients, are going to have long COVID, which may well affect their earning capacity and consequently affect the way in which personal injury damages are calculated. What about lifetime multipliers? Those, and it's always interesting to note, as you will recall, have in actual fact recently come down. So Ogden Tables 8, which was based on the 2018 based population, by comparison to the 7th edition, which was based on the 2008, 10 years apart, there was between a 1% and 2% reduction in the life expectancy between those 2 years. What about the 9th edition that's going to be published? And what about the position in the meantime? Well, immunization in the prevention of serious disease may well have a significant effect on the trajectory of life expectancy. But what about those people who of course, are particularly vulnerable? Those age 50 plus, all of those people, and on an increasing scale moving forward, who will be more significantly affected, or have been more significantly affected by COVID, and will likely be so in the future. What about on the one hand we have immunization, but then we have new variants. How good will they be? And what about the clinically extremely vulnerable? For example, those people with Down syndrome were considered 30 times more likely to die from COVID. What about those people with diabetes? Again, very significantly increased percentages of vulnerability to COVID. To what extent is immunization going to affect them? So all of those particular matters will need to be brought into account in our schedules moving forward, and in our counter schedules as well, in riposte to claimants' claims. What about those damages that may possibly have increased? Well, I say this in a sense a bit tongue-in-cheek. DIY gardening and decorating by bubbles or partners, well, they may well have increased. But not a great deal else. Perhaps some care might have increased, because you had live-in or round-the-clock care where people had to stay within a bubble and were unable to dip in and out? Is that an additional cost that's recoverable? And what about those other procedural issues that we all have to deal with, and no doubt have been dealing with over the last 6 months, but are going to become increasingly important to us to make certain that all of those points that I've mentioned are put into amended schedules and counter schedules. We might need expert evidence to address life expectancy specifically, or contingencies other than mortality, and that might well involve employment expert evidence when otherwise we wouldn't have had it. And then, of course, we have cost budgets. What about them? Because, of course, it's important that with regard to all of these adjustments that we might have to make to our schedules and counter schedules, that we take into account CPR Rule 3.15a, which is that we have to make an application promptly if there are significant developments in the litigation which warrants such revisions. So we need to make certain that we carry out those adjustments to address those. What about COVID-related personal injury claims? I thought it most helpful perhaps just to break this down into 3 particular areas. The most likely areas where claims are likely to arise are inevitably going to be with regard to employment situation and employer's liability. Of course, we know that the take-up of PPE was extremely slow initially. Even in the 30th of November 2020, the BMA was stating that there was a lack of PPE, which puts both doctors and patients at risk of contracting a potentially fatal infection. It also presents doctors with challenging decisions about whether to provide treatment in the absence of effective PPE. Similarly, there have been a large number of studies. I found a very interesting study called Evaluating the National PPE Guidance for NHS Healthcare Workers During the COVID-19 Pandemic. And it states this: tragically, many of the infections and public deaths recorded in the global coronavirus pandemic have occurred in healthcare workers. Some have been attributed to inadequate provision of personal protective PPE. Again, there's a very useful paper in the BM in the British Medical Journal, recently published on the 20th of January, with regard to frontline healthcare workers' experiences with personal protective equipment during the COVID-19 pandemic. What was identified there was inadequate provision, i.e. shortages of PPE, inconsistent guidance, i.e. different guidance between different healthcare settings, and inadequate training. And as you probably heard on the radio this morning, the National Audit Office that prepared a report today made specific criticism of the way in which PPE have been provided to adult social care providers within the UK. And what was said by them was that that they only received 14% of the total PPE distributed, and they only received 10% of what in actual fact they needed. And then, of course, there is a large number of the PPE which failed to meet its required standards as well. Another point that was identified by the National Audit Office. How is that going to affect the claims that might be made in employers' liability claims? Well, certainly in the context of healthcare workers, that there is very good recording now of the deficiencies. What about other areas? These are somewhat apocryphal, but there have been studies. London bus drivers, for example, have suffered particularly. There was a review of the deaths, increased deaths of bus drivers in London, published on the 27th of July 2020, and it was identified that drivers aged 20 to 64, in other words, those who were not in the particularly vulnerable cohorts, or they're over 50, some of them, but a significant proportion of them were under 50, and all of them were below 65, that there was a 3.5 times higher likelihood that the bus drivers would die. So very significant increases. So where do we take all of this? Well, as we know, we are now dealing with common law negligence, but personal protective equipment at work regulations usefully inform the standard of care. As it states at Regulation 4.1, every employer shall ensure that suitable personal protective equipment is provided to his employees who may be exposed to risk to their health or safety whilst at work, except where and to the extent that such risk has been adequately controlled by other means which are equally or more effective. So we have to look at some of that, have to unpack some of that. So Regulation 4.3, PPE shall not be suitable unless it is appropriate for the risk or the risks involved in the conditions at the workplace where the exposure to the risk may occur. That's subsection A, and then it goes on to say at B, actually, between these two that you've got in front of you, it takes into account the ergonomic requirements. It's capable of fitting the wearer correctly, and so far as practical, it is effective to prevent or adequately control the risks or risks involved without increasing overall risks. So where does all of this take us? Well, it's interesting to look at the timelines. So as many of us probably thought right from the outset, the wearing of face masks seemed to be a very sensible thing. In actual fact, a very sensible thing to have done right from the outset, right from the first announcement, I think, by the Secretary of State for Health on the 16th of March, and then subsequently the Prime Minister's announcement on that fateful Monday, the 23rd of March. But it took between the 23rd or the 16th, whichever one you wish to prefer, before anything was even done with regard to face coverings at all. It being the case, apparently, that they didn't, in actual fact, materially contribute to the safety of anyone within an indoor space or on public transport or indeed anywhere else, as far as one could tell from what the government was saying. On the 15th it took until the 15th of June for that to change, when it was stated then that a face covering was compulsory on public transport. That was announced on the 4th of June. And then it didn't take until the 24th of July until face coverings were compulsory in enclosed public spaces. But what are we going to be looking at here in terms of PPE? And how do we differentiate the question of face coverings from PPE? The HSE distinguishes between the two. They had stated, as you can see in front of you, but have more subsequently changed, not unsurprisingly, their guidance. But they still take the position that a face covering is not PPE. They do therefore say this with regard to face coverings. They say face coverings are mainly intended to protect others and not the wearer. When used correctly, they cover the nose and mouth, which are the main sources of transmitting coronavirus, COVID-19. The risk of COVID infection at work must be managed by following the right controls, and then sets out a number of controls: social distancing, high standards of hand hygiene, increasing surface washing, assigning and keeping people in shift teams, using screens or barriers to separate people from each other. These are the best ways of managing risk in the workplace. You can find specific guidance on working safely during the coronavirus elsewhere on the HSE's website. Yes, which they do indeed provide. But what about those situations where those control measures are inadequate? If one looks at the control measures that have been suggested, if social distancing with the workplace is not possible, then you come back to except where the risk has been adequately controlled by other means, which are equally or more effective. And then, of course, you get into a situation where, yes, in order to be able to discharge their obligation, their duty of care to their employees, yes, they do in actual fact need PPE, not just a face covering, and something that in actual fact does prevent, not simply stop. Prevent, not simply stop both the spread and also the catching. And as we know, there are a number of different types of face masks, none of which are expensive and are indeed now easily obtainable. These are so-called masks which have a PP3 number associated with it, or even a 2. So 2s or 3s, and certainly 3s are supposed, in actual fact, to prevent the transmission of disease, the catching of disease, not simply the spreading it from one, or to reduce the actual spread of the disease from an infected person. Now, all of that type of PPE is now readily available. It has been for some significant time. Indeed, you could buy it last summer, at a time when the HSE was still suggesting that in actual fact there was no evidence and it was unnecessary. But nonetheless, I think a very large number of people would have thought it was quite sensible and wasn't being something that ought to have been done. So, where does all of this take us with regard to any other possible routes to liability? We've got the Control of Substance Hazardous to Health regulations. I'm afraid they do not apply. It says specifically within the Code of Practice it's inapplicable. So just then moving on to where it is and how it is we're going to address the particular issue then of common law negligence. We're going to be looking at employer liability issues apart from PPE, of training in safe systems, of testing co-workers and isolating procedures. We're going to have not an unlikely higher instance of workplace stress. Again, we see that on the television all the time. And then we have unsafe procedures. For example, accepting COVID patients into care homes and the like, putting employees at risk. And then we have, of course, the state of premises screens to protect employees and customers. So those are all the points which have been drawn out in essence by the HSE and their guidance. And when we're dealing with those, it's always very much going to depend on the timeline, isn't it? After the 23rd of March, it's going to come down to the usual checklist for common law liability. So the knowledge of the risk, the knowledge of the precautions, the magnitude of the risk, the individual characteristics of the claimant, i.e. whether someone was exceptionally vulnerable, yet notwithstanding it was stated they had to appear at work in person. And then we have the practicality precautions, and we have employers' resources, and then we have statutory codes and guidance, some of which I have looked at. And then we're going to have other issues, aren't we, with regard to causation, which are always going to be interesting. We're going to have the but-for test, but maybe the but-for test doesn't help us so much here. Perhaps, which of course it isn't necessary that the but-for test is the only test to apply. There's no need for, of course, for exclusive causation. There may be more than one cause, and of course we have question of material contribution. Now, one of the issues that I think that we're still waiting to learn about is the extent to which COVID-19 is dose related. Certainly, there has been some suggestion that those people who have had particularly large doses of COVID have in actual fact suffered particularly badly from it. And that particularly applies to healthcare workers. So, moving then perhaps to the final point on causation, which is the issue of increased exposure to risk, i.e. analogous to the industrial disease position. Is that how the litigation is going to shake out? Certainly the point is arguable. And then just finally, with regard to the employment context, of course, as far as families of healthcare staff who have died as a result of coronavirus, they are entitled, or their families are entitled, to a 60,000 payment from the government. The guidance is online. It was published on the 27th of April 2020, and it said that the scheme is designed to cover frontline staff in England, and it's extended indeed to Wales, Scotland, and Northern Ireland as well. And it is quite wide in fact in its scope. It's for statutory NHS bodies, and their employees. So trusts, special health authorities, clinical commissioning groups, NHS England Improvement, GP and dental practices, including GP dental contractors and GP locums, Department of Health and Social Care, which are said to be at arm's length bodies, including Public Health England, and then wider non-NHS organisations that provide NHS funded services and functions, including commissioned services and outsourced services, and organisations delivering public health grant funded services. And also for adult and children's social care, all employees of local authorities, care home providers for children and adults, domiciliary care home providers, and directly employed carers, including personal assistants, where some of the funding is public for the care of service users. So it's very widespread and a £60,000 payment. What about occupiers? Again, we're going to be getting ourselves, as is always the case, into greater difficulty in terms of being able to get home on liability, and defendants are going to be able to more easily defend these types of cases. But nonetheless, there are going to be visitors to hospitals. I don't know whether if anyone visited hospitals during the early part of the lockdown. I mean, I went to a hospital in May. And was astounded to find that absolutely no one in my local hospital was wearing a face mask. They were moving what appeared to be COVID-infected patients around on trolleys through corridors, again, without anyone wearing any face masks. So I suspect that there is a real risk that some visitors to hospitals may have contracted COVID. Residents and visitors to care homes, visitors to shops. We've all seen that picture of that sort of moving picture of the spume, if you like, or the air of moving COVID air that would have been applicable potentially to shops up until there was the compulsory wearing of face coverings in July. And then we have visitors to offices and other public places. Again, one of the questions that might arise is whether or not there have been appropriate control of access to these premises through allowing too many people to enter, whether or not there had been a failure to have enforced social distancing, or in allowing, for example, an employee to remain on the premises, notwithstanding a positive COVID test. And of course, it may well be also that liability might arise under the Occupiers Liability Act for the common duty of care due to the state of the premises, because someone who subsequently identified to have been suffering from COVID who was working there wasn't behind a screen and infected a visitor. Of course, in all of those particular instances, there may well be a lot of difficulty in bringing to bear the evidence to prove what it is that a claimant will inevitably need to prove, both in terms of breach of duty and secondly, more particularly, on causation. But there will inevitably be some unique and interesting cases that will come out of everyone's collective experiences, and no doubt some of you are already having to deal with those types of cases already. And then finally, we have treatment and care, which in essence is clinical negligence. We have patients in hospital, patients and GPs practices, and we have residents of care homes. This covers, of course, a complete panoply of different and large number of issues, of course, which includes all of those normal matters we'd be familiar with in the clinical negligence context. The transmission of disease within the hospital setting is a known phenomena, and of course there are reported cases in relation to it. But it is somewhat of a topic in its own right. So I'm not going to address the detail of those particular matters now. But those are all issues that no doubt are likely to arise in due course, either mixed up with the occupiers and also with the employer's liability, or in terms of a singular causes of action of themselves. So what about long-term effects? The long-term effects, as we know, all of our trials and final hearings have all been pushed back. We don't know when, in actual fact, we're necessarily going to get matters heard. It very much depends where matters are being dealt with. As we know, QB Masters, for example, have got on with cases pretty well throughout without any difficulties. In contradistinction, some county courts have simply gone to sleep. So it very much depends on where the case is being heard and the extent to which the local protocols are encouraging the parties, in actual fact, if trials are offered to them, that they should be both, they could be hybrid or they could be totally remote. For example, on the Western Circuit, they have a checklist. If the parties don't wish to go ahead with a remote or a hybrid hearing, then the trial won't be heard and the matter will be adjourned. So it very much depends on which courts you're in as to how matters are going in due course to be dealt with. As I've already mentioned, we're going to have discounts for contingencies other than mortality. We're going to have life expectancy in the Ogden tables, and we're going to have loss of earnings claims. All of those have been very significantly affected, perhaps disproportionately and more so than perhaps in other areas, and are going to affect us in our practices long term moving forward, and matters all of which we will need to be taking into account. That's everything that I wish to say. Thank you very much. I think there is a question and answer function, so you can ask any questions if you wish. I think one of the questions was why face masks don't work. In terms of the answer to that particular question, I think it comes back down to the nature and type of the face mask. So certainly a face covering stops you from spreading it to someone else. But unless you've got, in actual fact, a type of face mask which is sufficient to prevent disease being spread to you, you don't necessarily get the benefit from not being able to catch the disease at all. Well, I'm told by Robin Talbot that the clip disproves that. Well, of course, it will all be a matter for evidence, and I'm sure that there will be a great deal of argument about these particular points. Certainly, as far as the proposition is concerned, that face coverings are sensible, and I'm certainly in favour of face coverings, and I very much do see there being a significant potential for future litigation in relation to PPE as opposed to face coverings. In other words, why isn't an employer providing a PP3 face mask in circumstances where they can't guarantee that social distancing can be maintained at all material times? There's another question here. Do you see in the future an extra Ogden table for those who had COVID and those who didn't? Or will ONS just change the blanket average life expectancy if it changes? I think we're going to get blanket changes because Ogden has always been has always based itself essentially on as far as the Ogden tables itself are concerned in terms of life, it's been always based itself on averages. So say, for example, we've always had smoking, for example, has always been included, and other known conditions and diseases are all included within the statistics. And there is an element of dead reckoning. Obviously, there are inevitably going to be individual cases where you might need to adjust the tables to reflect someone's particular circumstances, but I doubt that the Ogden tables themselves will be changed. But I do think the contingencies other than mortality, that is, in a sense, that's perhaps more likely where you're going to see some adjustments, and there may well be some learning on that in due course. Any other questions from anyone? Well, thank you very much indeed this afternoon. I hope that has provided some useful insights with regard to issues arising from COVID. Of course, there is going to be significant and substantial developments, I think, over the forthcoming periods of time. one thing we do need to bear in mind, of course, is a simple point as far as personal injury is concerned, is that it's a relatively long, but it's a relatively slow burn. Because of course, if we have our first lockdown on the 23rd of March 2020, then we got 3 years in which to issue proceedings. So not until the 23rd of March 2023. So there's quite a lot of time yet for everyone to have issued those claims. And of course, that doesn't, in actual fact, take into account all those people who in actual fact, perhaps the most significant period of time, which is going to be from March through to July of 2020, and then no doubt in very many specific instances in the workplace in particular, since then, that are likely to give rise to people having contracted COVID in circumstances where otherwise they may not have done. And of course, there is going to be a very significant number of I think a significant number of inquiries, if not cases. And of course, this is going to run and run because many of these individuals may in actual fact be protected parties, or they may even be in certain circumstances children in a school setting. And there will be lots of expert evidence and legal argument to address all of the issues and the risks that everyone faced. No doubt much informed by retrospect, but we'll just have to see how matters develop. So thank you very much indeed for coming, and that concludes the seminar. Thank you.